SJC-13428, Commonwealth v. Khalid, Kalila.
May it please the court. My name is Jay Carney, and I represent the appellant in this case, Khalid, Kalila. I've been thinking this week about the fact that I became a member of this bar in 1978 as a full-time Massachusetts defender in Boston. And I distinctly remember the cases of Levin and Allen and Hodge, where this court or the appeals court made it clear that there is almost a presumption that a person would get a stay provided that there was a meritorious issue to be presented and there were not facts that would support that the defendant was a danger to the community or a flight risk. I was very pleased to see in Nash, this court reviewed with greater detail the basis for a stay of execution. But in essence, it was the same standard that this court had set in 1979 and 1980, excuse me.
Of course, on that fascinating issue, you clearly have, on the heft issue that's going to create a dialectical discussion, you're good there. I'm not even sure the Commonwealth would say otherwise. So moving on to the security flight issues is probably where we're going to be here.
Yes, Your Honor.
And can I layer onto that one thing, additional thing?
Certainly, Your Honor.
Which is, we seem to be saying that if the security flight possibility is high enough, that's determinative in this context, right? We've said that, right, multiple times.
Yes.
Okay, so go for Justice Lowey's question then.
But my claim is that both Justice Raschuti and Justice Desmond abused their discretion by taking a perfect bail argument on behalf of someone and turning it on its head and saying, see, he's been working full-time at the same jobs that he was working at before he was arrested, and through the 3 years that he has been awaiting trial, he's been working at the same job. And that's so he can save his funds to flee. Where the heck did that come from?
It's the speculation that is the most problematic, Mr. Carney.
Yes, it is, Your Honor. The problem is the defendant's background was one of the best bail arguments a lawyer could ever make. And I speak as someone who spent 40 years of my career arguing for bail, and the other 5 years arguing for a little bit more bail when I was a prosecutor. But my point is that when you look at this person's background, he was born a United States citizen because his mother was American and his father was Moroccan, so he had dual citizenship. He came to the United States when he was 13 years old, and he married his high school girlfriend, and when they were 18 years old, and they moved here and stayed here. They had 3 children.
So we might make a different decision than Judge Raschuti, but I mean, our review is for abuse of discretion. Why, why couldn't Judge Raschuti review this differently than the narrative that you're saying?
Oh, I think he gave a clue.
Those factors indicate that the defendant has the capacity and now the impetus to flee.
It was pure speculation.
Well, is it?
There's a quote I put in there about sometimes a lawyer will give a reduced fee for someone to do the appeal. That was not excluded as a consideration by the court. He just speculated that they've got all this money and will use it to flee. And the problem is,
Based on, I thought there was something in the record about the defendant actually going to Morocco.
yes,
Okay.
he had gone to Morocco with
So it
his
wasn't
wife.
pure speculation, it was based on evidence of actually doing it.
He went to Morocco with his wife and 3 children. They had an aunt in Morocco still. All the rest of the family had moved to the United States, except one brother who moves to Germany. But I think Judge Raschuti gave a clue as to why he had this problem on the stay. He twice stated that Mr. Kalila can leave this country and evade the punishment which I have imposed. And the second time he talked it, and he said, escape the punishment I imposed. Well, if you're looking at a decision on whether to grant a stay of execution, you simply have to know that a stay of execution will prevent a person from immediately serving the sentence. That happens in every single stay.
When the appeals court fights over this, they recognize maybe some of the overstatements, you're talking about, but this person has a viable life in both places. He has connections to Morocco. His father's there. He has family connections there. He had a passport there. Both decisions both of the milky massing description of all these factors are both plausible. So doesn't that come down to there's no abuse of discretion here? They're both reasonable interpretations of this possibility of flight.
Because it's not reasonable,
Really?
respectfully, Your Honor.
He's not a defendant with no obvious place to go. He also has a very supportive family, which is fantastic. So he's not financially on his own either. I mean, I recognize your point that the judge overread the financial point and shouldn't have been focused on the fact that you're so good and so expensive, whatever. But there is sort of a very global description of all of the relevant factors, by both single justices and the appeals court, and it comes down to a discretionary call, doesn't it?
An abuse of discretion should not be as rare as pigs flying. That's my favorite quote of the last 45 years.
I think that was
But the way it's, I'm sorry, but Your Honor, the reason why it's an abuse of discretion, if your statement just now that if a person comes from another country,
No, I'm
then
just saying
he can't be released.
It's not, again, the trial judge goes through a lot of factors. He is not someone without connections to Morocco. He visits there, his father lives there. He's not, we're just not projecting flight out of the country in some undetermined way. He also, the trial judge has the benefit of having been there for the trial. I know you think he's trying to, enforce his rule, but he also observed the trial testimony on credibility. He has a sense of what could happen on a retrial that's probably better than anyone else's. It may be prejudiced, you're saying, I guess, but again, it's abuse of discretion standard, and it's going through all the Nash factors. Nash, again, Judge Massing talks about Nash as being emphasized that you didn't really even consider the factors, or you undervalued them dramatically. Their judgment calls on each of these factors, and you can go both ways, as the two appeals court justices do. But it seems...
Respectfully, Your Honor, you can't. There has to be a point where someone is going to abuse the discretion. For example, saying this defendant came from Morocco. He came to the United States at age 13, already a United States citizen. He graduated from the local high school in Revere.
He's a
He began
tremendous
working.
success story here. I think Judge Milkey does a very nice job of saying it's going to be tough to leave this country for this man and his family.
Well, you should see his first opinion.
Right, so I get that. But at the same time, he's facing going to prison for 4 to 5 years. He knows what happened last time. Even if this gets reversed, he's going to be retried. And his life here is not going to be the same if he's convicted, right? It's just going to be dramatically different. He's going to be away from his family for 4 or 5 years. Will he run to a place he has connections to where his dad lives? Can we really, it's just hard to substitute our judgment here, I find.
It's an abuse of discretion to say simply because a person has a relative in another country and every summer he goes to see that relative.
More than that, it's that this man's life, there's a distinct possibility of him going to jail for 5 years. And that changes your calculus. Even if you love this country and you've been a great success here, that's frightening for anybody. So it's not just that he has family in Morocco. It's complicated. There are a lot of these factors when you go through them that makes this guy has a terrible decision to face.
Like what, Your Honor? Like he hired private counsel, and so we're going to hold that against him? That's what Judge Raschuti did, held it against him that his family hired me
I
to
agree
represent
that
him.
that was probably ill-advised. But again, the appeals, Judge Massing talks about that, and I thought in an intelligent way puts it into the calculus, diminishing it, by the way.
Justice George, Justice Lowy, Justice Gaziano. The three of you have an advantage of having set bails for years. And I'm not being disrespectful to Your Honor.
A totally appropriate comment.
But the three of you, have set bail for years. And if you look at this person's background, and he's being arraigned in the South Boston District Court in the morning after an arrest the night before and bail being posted at the police station, he shows up at South Boston for his arraignment.
Mr. Carney, the point, though, is bail is different, right? I get to make that point as an appellate judge, right? Bail is a different determination than this. This is a different standard, correct?
No.
Oh, I
This
think...
court has said repeatedly that the process that a trial judge should use in terms of setting an amount of money for a stay of execution is the identical process that you use to set bail because the same factors.
I'm not going to read other cases that say the standard is different. Here, we've got a lot of cases out there. Does Nash even make that point? I can't remember.
I can't remember.
The presumptions are different. That's the issue, right?
Right, but the factors you're
Factors are the
supposed...
same, yeah. We've said that you have to apply the bail factors, but the presumptions of liberty are different.
Why don't we do this? You have a minute left, and there's part of your brief that the Commonwealth doesn't really address, and there's part of their position that you don't really address. I don't think they address your point of the factor one so strong that should feed into factor two.
Absolutely.
And you don't address that, okay, factor one strong, but factor two has to account for that he's already been convicted once and may choose as Justice Kafka is suggesting, to take an opportunity that he has rather than being convicted a second time. And I think, I'm not saying they can't address your point, and I'm not saying you can't address theirs, but why don't you take a shot at addressing theirs?
At addressing their
Well, the
issue?
point, he can be retried. He's been tried once and been found guilty. He's got a risk of flight because 5 years is a long time. Even if your Horatio Alger and all's done great, doesn't mean that you that you necessarily want to play those odds.
I perhaps showed hubris during the stay hearing when I said to Judge Raschuti, I have educated my client into what structural error means.
I
And that-
can't believe you showed hubris.
What's that?
I can't believe you showed hubris, Mr.
Yes,
Carney.
hubris. And
That's
I
your
told
argument on-
I told the judge that I've told my client that this conviction will not stand. And I said that to Judge Raschuti. I explained to my client,
That's where we started, though, Mr. Connie. That's where we started. That I think you got a really good issue. That's at a minimum an issue of heft that's going to be an impetus for a dialectical discussion. I think you're good. And they're going to have to address why that doesn't leak into point two, as you've suggested it does. But you've got to face the as far as abuse of discretion issue goes, what they're going to say is, yeah, we had a really good case. We still have a really good case.
the jury was out for 4 days of deliberation. That shows that there was a lot of discussion going on a very straightforward case. 4 days of deliberation. Those jurors are trying to weigh what the allegation was. And so keeping a jury out for 4 days, that shows the trial had some legs.
On the issue of abuse of discretion, can you list for me, Mr. Carney, the things Raschuti got wrong as far as the speculation goes?
Certainly. He refused to appreciate that the defendant was born an American citizen and came to the United States at age 13, attended local school in Revere, and then began working as a maintenance person, overseeing 60 employees at, I think it's 9 different settings, including Granite Links, a pretty terrific golf course. Then he has 3 children.
I don't think that's, if you don't mind me saying, just, I don't think that's your question. What the argument was for bail is what he should inappropriately consider.
Right, because the first point you made, that he took the money part of it and said he's stashing money to flee the speculation. That's, to me, that strikes a chord. Are there other things like that as well?
His view that the defendant has sufficient family in Morocco to move his wife and their 3 young children who have permanently resided in Massachusetts, that they would pick up and leave. Another thing he got wrong, which we've already discussed, is the fact that I'm a private counsel is a factor that should be considered. And I submit it should not be. Mr. Kalila had no prior criminal record except
Can you
for,
stick to the errors? That just, it would be really helpful, because your best chance of reversing this is what is not sort of marginally left out, but what errors did he make? So it seems to me it's the stashing money and private counsel are the 2 that you emphasized. Is there any?
I think you also mentioned the bail, post and bail issue.
well, he had posted bail the night of his arrest at the police station. The court the following morning kept the same bail. The case was added to when the government sought a criminal complaint for mayhem. He was arraigned on that, and the bail stayed the same. Then he appeared in the Superior Court. The bail stayed the same. He was on that bail for 3 years during the period of COVID. He never missed a single court
But the
appearance.
judge noted he never missed it. He noted he was a model citizen besides this event. Again, trying to focus on errors.
All right, here's one of the errors he made, saying that if I grant this stay, the defendant would either evade or escape punishment.
Does he do that in his opinion, or is that somewhere else? That's in some oral, does that appear in his actual decision, or is that something you're pulling from the transcript?
It's from the transcript of the stay hearing. And he says it twice with that one word difference.
Did he also, was there an issue of extradition that he got wrong?
Yes. He said if he goes to Morocco, we can't get him back. Well, we've submitted in our brief that there is an agreement, and has been for decades, with Morocco to extradite people from Morocco to the United States. So he got that fact wrong.
And was there an error about the passport, the ability to get a passport? Was there also an error on that or not? I can't remember.
Yes. Judge Raschuti said he can just get a passport and leave the country. And it turns out, in order to leave the country, he has to go through Homeland Security. And he's got to present identification.
But I think Judge Rassuti is saying he'll have a Moroccan passport that's valid, and therefore he can go through passport control.
If he is barred from leaving the United States, that shows up in the Homeland Security records. And if someone tries to leave the country, they get caught at the border, at the airport.
Whether or not they have a foreign passport?
He had an expired passport and a present United States passport.
So if someone comes in, I just want to, again, because I'm focused on errors, not quibbling, but if someone goes with a valid Moroccan passport to the airport, it is going to really register with, and their name is not some incredibly unusual name, it's going to register that you're on a list banning you from leaving the country? Because he's not using his American, I understand if he was using his American passport, but he's going to be using, in Judge Rashuti's example, a Moroccan passport.
If he were barred from leaving the country, which is not an unusual condition of release imposed by judges, then the word is conveyed to Homeland Security that this person cannot leave the United States.
And we'll find that in the record, Mr. Carney?
I'm sorry?
We'll find that in the record, right?
In my brief, I gave the court the guidance of that.
Okay.
And that one has to go through Homeland Security and show that you are allowed to leave the country.
And I'll just ask you, Mr. Carney, the time remaining, could you let us know if there's any other errors you want to point out in the decision?
Sometimes when you see clues that a judge is purely speculating about stuff that in fact has no basis in fact in the record, and the judge twice says, if I grant a stay, he will escape the punishment that I imposed on him, and variations of that twice. That's not a judge who is honoring the teachings of this court, whether it be Levin, Allen, and Hodge, or Nash. And that's another error that clouds everything he said.
Thank you, Mr. Carney.
Thank you, Your Honor. Thank you very much.
Attorney Jordan?
Good morning. May it please the court, Darcy Jordan on behalf of the Commonwealth, and with me is ADA Lynn Feigenbaum, who's the trial attorney.
Sorry.
That's okay.
Can I ask you to start with the question whether a strong showing on likelihood of success
Sure.
has any bearing on the analysis under the security factors?
In short, no. I do go into at length in my brief, and I think this is the real nugget before the court, is how these two distinctive factors, if they should at all.
The question.
That's
So
the
what-
question.
What's your answer?
My question is no, and I think if I could start at the end and explain why, I think to do so is to really invalidate what a legal, valid verdict, a judgment means in the criminal justice system. And if we could just hear me out, because in motions to stay, the first factor as it currently stands, the defendant just needs to raise a claim of error. It's a very liberal threshold that benefits the defendant, as it should, right? Because we're saying,
Right, but this
Right, but-
defendant didn't make just a sort of, hey, this passes the laugh test kind of thing. He made a quite substantial
Right.
argument that there is going to be a reversal of this verdict.
yes, he did. And I suggest what the defendant is postulating is that the defendant in a motion to stay not just raise a claim of error, right, that will be eventually litigated by a panel in the appellate courts, but is basically raising to say my claim is so strong that it rebuts the presumption of the valid judgment, that it so deems my current valid sentence after a valid legal judgment illegal. And I think what that then has to logically mean is that that verdict from the trial does not mean that final judgment. And what that
Well,
has
it's not final.
well, it is final for the purposes of sentencing, and that's really what we're talking about, or I should say it's the purpose of curtailing the defendant's freedom, that the verdict is final, because we can probably all agree that the word finality in the criminal justice system has different meanings in different contexts, right? Because we can talk about the judgment, a verdict, having finality in that it allows for the curtailing of freedoms and the abrogation of substance and substantial rights. But we can also, as an appellate court, talk about the finality of judgment and say a rescript. And we can go on. I could, believe you me, as an appellate attorney,
This
but
particular
but-
issue, why shouldn't we consider prong one in analysis of prong two? To me, if you have a really good case that this is going to be flipped on appeal, it might affect things like flight,
yes, and
the likelihood of flight, right? If I'm definitely going to get a second shot at this, maybe don't go.
well, yes and no, and I think that dovetails to a question that Justice Lowy had raised to my brother. But I think what we have to think about is how does this process work? That valid judgment that we talked about by the jury, that can only be abrogated or vacated or overruled by an appellate court. And just by raising the claim that I have a strong claim in a motion to stay after that verdict isn't enough to rebut the presumption of that valid verdict.
So I guess my suggestion is not that just raising the claim, but raising the claim, citing the cases, and saying, I'm just like that, it's pretty good.
Right. Well, I think just not like that if we look at the appellate brief that we also argued. I don't think it's that simple to say that, because what you're basically saying is that in a motion to stay, a defendant can raise an appellate issue, essentially litigate it based on the facts and the record, and prove essentially that my judgment isn't valid. And I think that is totally contradictory to our whole criminal justice practice.
Right, but
Also, aren't we, all you do is go back to trial. You can get hooked again. I mean, so, and you can get hooked again, and the idea that the strength of the appeal might be so great, wonderful, but you might be right back at square one and right back at square two when the verdict comes back the same way.
Right, and now you have a different judge with a different opinion based on fact, not by an appellate court, but also if I could tail dove that into what this, again, globally means. Because if this idea that there's a claim so strong that it's so obvious and egregious that will warrant vacating, well, if we take a look at what really happens at trial, there's a whole universe of remedies if such egregious error that arises, right? And we trust our trial judges to remedy
So
that.
the judge forgets to instruct on an element, the judge should grant them a motion for new trial.
Exactly, or we can talk about 211.3, or even if it's immediately thereafter, 25B. But when there's a verdict, it meaningfully changes not only the government's interest in that verdict, but it changes the remedies available to the defendant. And a motion to stay
But we're analyzing the judge for abuse of discretion. Let me posit the way your brother argued for a second. Okay, we've got an error here that's basically every judge who's looked at it now is concerned about it. 2, the trial judge sort of is rewriting a little bit, so he's concerned about it too. 3, that may be affecting his analysis on the other side of things. I think that's what we have to worry about. Is the judge analyzing the security issue in the context of dealing with his own error or potential error? And that's where this gets a little more complicated, right? Because this looks like a reversal. Let's be honest.
Well,
it looks like a reversal. The appeals court is essentially recognizing that too. But again, there's going to be another trial on this thing. But it looks like a reversal, and the judge is digging in a little bit.
I respectfully disagree based on my appellate brief that
You think you're going to win this one on the jury disqualification issue? Just let me pose this. You think you're going to win that one, basically that it is, forget about genuineness, but that it is not an adequate critique to say that the juror has family members in the very police department that's investigating this? I've read about 10,000 cases where we say that's adequate.
I think my brother and I frame that issue differently, and I frame it differently respectfully than Your Honor, because in those cases it was isolated to one juror, and the Commonwealth's postulation, which was the judges, is that
relates to genuineness, not adequacy.
And I think, and again, as I described in the appellate brief, that I think he was struggling with the idea of implicit bias, which I know this court has addressed, and it is real, and it's definitely hard to harness and identify and create rules around it. And I think that's exactly what the justice was struggling with. But I think as the Commonwealth, and I agree with how the justice and that Judge Raschuti framed it, was that it's not isolated to that one jury. And I don't disagree with you if it was isolated to that one juror. But here we have a comparative juror where the judge said,
just back up on the facts. There was another juror who had family presently in the Boston Police Department?
No, other police. And I think what's going to come down to
And the
there,
witnesses were from the Boston Police Department?
That's correct.
Okay. So
And I think
nobody who was identical to this particular juror?
Correct. And I think what's going to come down to there is whether or not it was an abuse of discretion for that judge to look at that categorically wider than the defendant is offering.
So then we've got to get into this security analysis. And again, I read it as a separate inquiry. But at the same time, is the judge overly committed? Again, he doesn't make, Mr. Carney just talks about the judge saying, escape my judgment or evade my judgment. He doesn't use that in his decision. Do we consider that? He says it at the transcript that he may evade my judgment or what? I haven't read that.
I think he was saying evade, period, end of story. I don't think he was necessarily, I think Judge Raschuti was saying that the defendant's possibility of leaving, regardless of the decision on the first, the first factor, outweighs everything. And I think what Judge Raschuti was doing was applying Nash, right? That the first question is strictly a question of law. Do you cross the threshold? Okay, I get it, and he says, I might have muddled it, but let me clear it up. And but all day long, you cross that threshold. We're not dealing, the law does not provide for this apex, and I think it doesn't because of some of the reasons I described earlier. But what Judge...
It certainly doesn't. They want you to be able to bring that, to satisfy that prong, but I think Judge Wentland's question is, when it's really clear it's an error, does that somehow impact the analysis?
I guess my answer is, I think that's an erroneous reading of the law, and I think why it's erroneous is that it contravenes what final judgment in the trial sense, what that means.
But
So it's sort of Commonwealth versus Hernandez is not irrelevant to how we think about prong one.
Exactly, and I cite Hernandez for exactly that idea, because what my brother is asking is basically for the court to move the goalpost of what finality means in a criminal system, right? Because finality of judgment, this valid judgment of a jury verdict, it allows for the abrogation of the defendant's rights, right? So we say, you don't get to go home unless there's these other countervailing factors, which Rashidi says are not present here. But what my brother really wants to do is say, it's not final judgment. We're going to presume my sentence, my judgment, and the sentence is illegal. We have to presume that until rescript is really what he's asking for. To say, I should be out free because I have a great appellate claim that hasn't been litigated.
I think that you're overstating the argument. I would state it as follows. Prong one is a very low threshold. But if I make a really compelling showing, it might affect the analysis on prong two. It's not saying that the conviction isn't quote unquote final or there hasn't been a jury verdict. We're not getting to those issues. We're just saying when you make a really compelling argument and you've shown it in your motion to stay execution, it might be something to consider when analyzing prong two. We're not getting rid of the jury system or sort of the parade of horribles that you're envisioning. We're just saying consider it in the analysis.
And my illustration is in the parade of horribles, but it's more indicating that there is purpose and meaning for the way it is right now, that it's a threshold and not an apex of
So
claim.
there's no sliding scale in our case law.
Right, and I think the reason there is no sliding scale is because that preserves the appellate process, which allows only for the affirmation or vacating or remand back.
It'd also be incredibly difficult to apply in a truncated appellate setting.
Absolutely, and I list a few reasons why I think it's not, overall.
Attorney Jordan, how about this, though? Because you really haven't touched upon Attorney Carney's point. At some point, doesn't this just become illusory, then, the potential for a stay after a sentence? I mean, if you look at somebody like in Mr. Kalila's position, and one thing that Attorney Carney didn't mention is some of us have been in a position of granting stays, and those people are still in the wind. And I have that. I have that that in the past. And so back to what Justice Kafka was alluding to, that you're doubling down on the fact that you've made this error, and if the defendant is vindicated and before the second trial he's in the wind, and so therefore you can always reverse engineer security risks here. When we ever get to the point of an abuse of discretion, if you can always go back and say what Judge Rashidi does in this case, even though it has pretty much, it's not likely. There's nothing in the record to say any of this is likely.
Well, I think it goes back, it really is grounded in what an abuse of discretion is, whether or not there's relevant factors that are grounded in the record that have reasonable inferences. And I don't disagree with you that this idea of
Is it a reasonable inference for a married husband and father of three to just leave? And the reason why I'm mentioning that, it's not also in a vacuum. We're not talking about a 20-year sentence he got. I'm not saying that any deprivation of liberty is minuscule, but it was a 5-year sentence, right? And he's going to up and leave his family and move to Morocco and do all of these things and move them to Morocco for that?
I don't know, because I think what we have to do is what is reasonable in inference. But I think your concerns, they rub up and against the government's interest in this valid judgment that they have already. And I think of course there's tension between that.
Do you address the errors? Because that, I think, is, if you're satisfied.
That's all part of the same thing, yeah.
Because I think, to me, Justice Gaziano's question about errors is the thing that, it's very hard to prove abuse of discretion unless we can point to obvious errors because this is really difficult. We don't know whether he'll leave or not. I mean, it's projections.
Right.
But address the errors, because Nash, from what I understand, the error was not dealing with factors. Here, the judge deals with the factors. The question is, are they erroneously dealt with? Can you go through the different errors?
Oh, I don't have them listed.
One after, here they are. There's that he's stashing money away, that private counsel has been taken as opposed to public counsel. I can't remember some of the others. The passport issue.
The extradition.
The extradition issue. Those are if you're going to lose, it's going to come out in there probably. So why don't you address
Sure.
that?
And I think it just also sort of dovetails with my other point that Justice Wendland and I were discussing, is that, well, if you can raise this claim and put all your eggs in the basket in the stay, well, then it makes all of these things much more incentivized to leave. I don't know if the court follows what.
There's a grasping at straws aspect that you start to read when you say, well, if he has a lot of money, he's hoarding money to flee.
Well,
that to me smacks of grasping at straws, which calls into question the rest of the findings. So that's what you have to convince me, that if he's speculative grasping at straws, the rest of the findings are valid.
Well, I think what Judge Raschuti does of close reading looks like he rebuts all the points made in the defendant's memorandum. And I think part of what he did there.
I win tells you lose. If he says, I have financial resources, he says, you're stashing money.
Right. I think
And further, you have a close family. Oh, they'll help you.
Right. And I think I conceded an oral argument that cuts both ways, which I think is part of the abuse of discretion standard. That if any of these factors.
Again, I think they all cut both ways. So address whether these are errors or not.
Well, I think the private counsel, is dealt with in the appeals court's majority opinion.
Which is what?
Which is basically that it's not as meaningful regarding getting counsel, right? Because there's this idea that then
I take it we shouldn't be doing this because you get to pick it raises constitutional issues if picking counsel is, right? I worry about that.
Well,
one.
I think because one of the factors in bail that we talked about guides some of this is financial resources. And I think that is what Raschuti is doing when he mentions the private counsel. I think what he's doing is trying to essentially hit the factors.
I ask, are there cases that say that's legitimate or illegitimate?
The financial?
When we do this financial means that you hired private lawyers, that you've got one of the major defense lawyers in the Commonwealth defending you, is that a legitimate thing to consider? I take it it's probably a bad idea.
I don't think I researched that particular fact, but I think in my brother's brief, it's supported by Brannigan, which says, the due process rights in a pre-detainee. And I do think that
the author of Brannigan's turning over in her grave at this point on that one. Well, actually, she's still alive.
I think because we're talking about are these errors, and I'm gonna say they're not errors in that Judge Raschuti is tasked with looking at the financial resources, and again, the burden is on the defendant to establish what finance he has, and that's how Judge Raschuti had.
I'm going to wrap it up with a question from Justice Wendland, please.
What is the difference between Mr. Kalila and Mr. Nash? In Nash, we said this was an abuse of discretion, even though the defendant had been convicted of 2 times rape, and he basically looks a lot like Mr. Kalila on paper, except Mr. Nash has not got the dual citizenship. What is the difference in your mind?
So there's 2 things that come to light if we're talking about that. Nash didn't have any of those other, it's balancing, right? He didn't have any countervailing points to what Nash had. So Nash did not have ties in other countries. And I did look at the underlying ruling in Nash, not just this court's opinion. Didn't have any of those a brother in Germany.
The difference between Mr. Nash and Mr. Kalila is that he's a dual citizen and has those ties in Morocco.
I think so, but also in...
Tell me why that's not a problem.
Well, because the task at hand is the possibility of flight. It's not the certainty. It is not, gee, do I agree with any of the incentive to do so? It's, is there a possibility that the defendant is going to abscond and not come back if that's so allowed? So I think, and in Nash, the error there was basically not looking at any mitigating.
Well, no, if you looked at the underlying opinion, you saw that the single justice did actually weigh the decisions. It just wasn't sufficient for this court to consider, it wasn't sufficiently considered. It was considered, but not sufficient. And on that basis, we said there's been an abuse of discretion by the single justice.
Yes.
Yeah. So the difference is that dual citizenship.
Well, it's not, I suggest it's not dual citizenship alone, but all those other things that either coincide with dual citizenship. It's not just alone, right? It's the family ties, it's the continuous relationship by giving money to those people there. So I don't want to say that it's just that alone, and that's the only distinction.
We have a last and final.
Okay.
So can you address whether the passport discussion and the extradition discussions were errors?
I cite to a federal case that is sort of on point on this, so I did attach it to my brief that talks about this idea of passports. It's not as, if you will, tight than I think has been kind of discussed in my brother's brief, that the idea that you can cross the border to Canada and get a Moroccan passport, it does not eliminate these possibilities. And that is not what the judge is really tasked with. He's not saying this is not convenient, or probably not, that it's the possibility of flight and whether or not he would go above and beyond to leave this country to avoid it.
Again, mine's a very technical question. Did the judge get wrong the discussion of passport and extradition?
I don't think so. I did look into what was available about this idea. I have no idea about TSA or that. I do know that this idea that he'd be on some list, I think that is not really borne out by the factual accuracies of what that means in practicality. So I think this idea that the judge was wrong in saying it's not as straightforward as the defendant is offering, I think that is an accurate statement.